appeal in the matter of the public institution, the social security, and Rajaan and others.
Good morning.
Good morning, my lady, my lords. I appear on behalf of the appellant. My learned friends Mr. Norbury KC and Mr. Richardson KC appear on behalf of the claimant respondent. This is the appeal of the 42nd to 44th defendants, who are the children of the former first and the second defendants, and I shall call them the children heirs as per the written documents. The respondent claimant is generally abbreviated to PIFs, so I shall adopt that formulation. The appeal is against the order of Miss Justice Jacobs, dated 16th December, dismissing the children heirs jurisdiction challenge, and the jurisdiction challenge itself was on the basis that the children heirs were not necessary or proper parties under the para 33.13 gateway. There's also a challenge to service of one of the children heirs, one of the daughters, Fager.
What company is that point?
Thank you. So there are two grounds of appeal, which on my submission each raise a short but important point of law. One, the succession ground. This is probably the ground we're going to spend most time on today, subject to the tribunal. And this is, in short summary, the court has no jurisdiction to add heirs under a foreign succession law rules as necessary or proper parties, simply because they are the foreign law heirs under the relevant foreign law succession to a deceased party in litigation where the deceased party's English estate is represented by a person representative of PR. And that, on my submission, is a question effectively of pure jurisdiction. The second is the company's law point, the section 1140 point, and my submission is that that was not intended and should not be construed as creating a standalone jurisdictional gateway where the person served, here the daughter Fager, would not otherwise be susceptible to service. And that, on my submission, is a narrow point of statutory construction of the words of the section. Now, my learned friend, on behalf of PIFs, also has a respondent's notice seeking to uphold the order on the additional basis which the judge declined to do, that the English court should, quote, recognise persons charged with the administration of a deceased person's affairs pursuant to a relevant foreign law as proper parties to a claim against an English personal representative of that deceased person. So again, I think the key question on that first ground of appeal and on my learned friend's respondent's notice is effectively whether a foreign law heir under a civil law jurisdiction can be a, quote, proper party for the purposes of the necessary or proper party test. And in my oral submissions before you, my intention is to follow the roadmap I'm about to lay out. First, deal with a small number of factual procedural points and look briefly at the Swiss law evidence, which I'm sure you'll appreciate is not contested. Second, look again relatively briefly at the relevant passages of the judgment and order below. Third, then turn to look in detail at my first ground of appeal, my learned friend's respondent's notice ground, the succession ground. Fourth, the second ground of appeal comparatively briefly. And fifth and finally, some concluding points. And that follows the map in my skeleton argument, and so hopefully won't come as much of a surprise. So, starting with my first set of submissions, the facts and procedure. As I've said, the children heirs are the four children of the deceased first defendant, Mr. Fahad al-Rajaan, and the second defendant, his wife, Ms. Muna al-Wazan. And Mr. al-Rajaan, as you'll have picked up, was the primary defendant in this very large fraud claim. I believe the trial is still, I'm told, day 86 at the moment in front of Miss Justice Jacobs. Ms. al-Wazan is a party in her own right, although she's not sued as a primary wrongdoer. Mr. al-Rajaan, prior to his death...
Sorry, she's a party in her own right and also as personal representative.
Correct, yeah. So when the claim was issued, obviously Mr. al-Rajaan was alive, so he was D1. D2 was his wife. There were then, I mean, an awful lot of other Ds.
And then the grants were
Exactly.
made.
I'm going to take you briefly to those grants in a moment. So, while he was still alive, Mr. Rajaan carried out estate planning before, in accordance with Swiss law. He chose Miss Al-Wazan and his children as his heirs, pursuant to a will. And he made an express declaration that he was domiciled pursuant to Swiss law, and I'll come back to the point of domicile in a moment. All of the children...
So in fact there's a Swiss will
There's a Swiss will.
and not an English will.
Correct. Yes. Now, all of the children heirs are resident outside the jurisdiction, and importantly, only one of them has any connection to Switzerland, him or herself. So Fawaz, one of the sons, has primary residence in Switzerland. The other son, Khaled, is in Kuwait, and the two daughters, Farah and Faja, are in California. And so the reason we're talking about Swiss law at all is because we are assuming, emphasis on the word assuming, that Mr. Al-Rajaan was domiciled in Switzerland at the date of his death. And on the hypothesis, again emphasise hypothesis, that Swiss law applies to the global succession. So then Mr. Al-Rajaan died on the 6th of September 2022.
Does it make any difference that he left Swiss immovables?
Difference in what sense, my lord?
Well, you said we were assuming he was domiciled in Switzerland, but if he'd left Swiss immovables, would the succession to those not be governed by the Swiss law wherever he was domiciled?
Without
Am I wrong about that?
Without that, yes. Yes. And you'll see when I take you to the pleading, that point is drawn out by PIFs. So there's two limbs to the enforcement ground. One is immovables, which on any hypothesis will be governed by Swiss law and will be subject to the jurisdiction of the Swiss courts. And then it deals with movables on the hypothesis that the domicile is Swiss.
So when you said the only reason we're talking about Swiss law at all is on the assumption that he was domiciled in Switzerland,
that's not quite
entirely.
It's subject to that important point. There is no dispute that there are Swiss immovables and that they would be subject. There are other immovables, I gather, in other jurisdictions. He dies on the 6th of September 2022, and the consequences of that for the litigation were dealt with in two stages. The first was an order of the 14th of November 2022, where Mr. Justice Jacobs appointed Ms. Al-Wazan to represent the estate under what is now Rule 19.12. And you have that at the supplementary bundle, tab 1, page 3. And it's in fact on page 4, so it's paragraph 4 of the order. Sorry, page 4 of the bundle. So you'll see that the order said the title of the proceeding should be amended, the claim form and all statements of case should be read as if the following heading was substituted, and then the first defendant is struck out, Ms. Al-Wazan comes in and her capacity as representative of the estate. But crucially at that point, no grant had been made. And so that is purely a Rule 19.12 point. And then second, about 5 months later, on the 26th of March, just turning over the tab, Mr. Justice Henshaw appointed Miss Al-Wazan as administrator ad litem and ad collegenda bona by paragraphs 1 and 2 of the order. And so those are the this is page 12 now. So it's divider 3, not divider 2. So at that stage, we have the limited grants by which Miss Al-Wazan is administering the English estate, and the claim against Mr. Al-Rajan's English estate was properly constituted from no later than the 26th of March.
And of course, the very nature of the the grant at paragraph 2 of Mr. Justice Henshaw's order is that it's the purpose of collecting, getting in, and receiving the English estate.
That's right. So it's expressly limited to the English estate in that part of the order. But as we'll come to later, the English court's jurisdiction only extends to the English estate in any event.
Yes.
Then there is there's a pause of a further year until the 27th of March 2024, and at that point PIF seeks to amend its pleading to add in the appellants, the children heirs. And the totality of that pleading is contained in paragraph 12A of their, I call it the five RAPOC, the 5 times re-amended particulars claim, the particulars of claim. And one sees that in the core bundle, divide at 10, page 139.
12A at the bottom.
12A at the bottom. And so you'll see that it opens with the words, in addition to PIF's claims against the estate. So it's seeking, obviously, to widen the claim. And then we can turn straight over to the following page, which is the meat of the pleading. So just taking it in turns, sub-paragraph A, if the first defendant's case that Mr. Rajaan was domiciled in Switzerland when he died, so that's the point about the assumption of domicile, and or that the administration of the estate is governed by Swiss law is correct. Now, there's no doubt, my lady, my lords, that assumption is wrong, because as I'll show you in due course, the administration of the English estate is governed by English law, but moving on. PIFs is entitled to and claimed against the Rajaan heirs on the basis that they are the statutory heirs of Mr. Rajaan as defined in the relevant passages of the Swiss Civil Code, and are jointly severally liable as successors, and I emphasise those words, as successors, to the civil liability of Mr. Rajaan under the relevant passages of the Swiss Civil Law Code. So paragraph A is a straightforward claim in succession. You succeed to this liability, therefore you are liable to me. That's then developed in subparagraph B, further or alternatively, regardless of whether Mr. Rajaan was domiciled in Switzerland when he died, PIF's claims against the Rajaan to ensure that it obtains effective remedies in circumstances where, and then A bis, as it were, Swiss law applies to issues of succession in the case of any Swiss immovables. This was my lord's point. Owned by Mr. Rajaan at the time of his death, and they're joined to ensure PIF obtains effective remedies. And again, the words I emphasise there are issues of succession. And then B bis, if Mr. Rajaan was domiciled in Switzerland, so he's domiciled in England, excuse me, a Swiss court would apply English law to, again, issues of succession in the case of any Swiss movables owned by Mr. Rajaan at the time of his death. And English law would, on the first defendant's case, follow Mr. Rajaan's selection of Swiss law in his will. Now, we don't have to go into this, but I say that there's a number of problems with that. You can't select Swiss law. We don't know about how the renvoi would work, but for present purposes, all that I focus on are the words issues of succession, because I'm going to say, as you'll appreciate, that this is a pure claim in succession. What they're trying to do is effectively say, because you succeed to those liabilities under Swiss law, you are susceptible to an order in these proceedings. And then the final paragraph, which is C, Mr. Rajaan held assets in different jurisdictions, including Switzerland at the time of his death, and other jurisdictions may, I emphasise may, hold that some or all of those assets have become assets of the Rajaan heirs, or some of them, and where an enforceable judgment against those assets in relation to Mr. Rajaan's liabilities depends or may depend, again may, on judgment having been entered against the Rajaan heirs. So that's a sort of pure hypothetical. If there are assets which we aren't identifying, they may be susceptible. They may be in the hands of the Rajaan heirs, so we're joining them for enforcement purposes.
C is enforcement again.
Yes, and you get that because it's in the obtains effective remedies subparagraph. Now that is, as I said earlier, the totality of the pleading. But you'll appreciate the net is cast extremely wide, because that last subparagraph is a straightforward claim to all worldwide assets that may be in the hands of the Rajaan heirs, if they're called the children heirs. And so what one gets from that on my submission is that there are two ways that this claim is put against the Rajaan heirs, the children heirs. First, subparagraph A, as successors to liability straightforwardly. And second, this to obtain effective remedies point, the enforcement ground. But again, that in turn only works because they are successors. And I've shown you the wording that I say establishes that. And so what I say is that the whole of this plea is in fact a succession claim. They are being claimed purely as successors or as a result of issues of succession. And so that brings us to the Swiss law basis for what is said in these paragraphs, which is in Professor Jakob's report, the expert report of Professor Jakob, which is at supplemental bundle, divide 14, page 128. One can move straight on to page 133. And this is just the summary of the conclusions, but as I say, this isn't in dispute. So paragraph 1, you've got the principle of universal successions and the heirs automatically succeeding to the decedent with regard to all assets and liabilities, and there's no succession of individual heirs. And so the heirs as a group jointly assume the decedent's legal positions. And then paragraph 4 down the page, the heirs are not forced to accept the automatic acquisition of the inheritance if the estate debts clearly exceed the assets. They may disclaim their inheritance for any reason whatsoever. The deadline to disclaim is 3 months starting at the time the statutory heirs learned of the decedent's death, or the appointed heirs receive the official notice of the decedent's will. If the heir fails to declare that they declaim the inheritance within the relevant time limit, they acquire it without reservation. The deadline, however, may be extended or reinstated for good cause. So that's the disclaimer point. And then 5, any heir able to disclaim the inheritance may also request a public inventory. The deadline to request such an inventory is the same as the deadline to disclaim the inheritance. Unlike the deadline to disclaim, it's uncertain whether the deadline to request a public inventory may be extended or reinstated after the inventory has closed. And, after the inventory is closed and been made available for perusal by the heirs, an heir may then still disclaim their inheritance. Request official liquidation or accept the inheritance. Where an heir makes no declaration, they're deemed to have accepted the inheritance. Subject to public inventory, meaning the heirs is not liable for any debts not listed in the inventory due to failure to register them on time. So again, you've got these two substantive provisions of Swiss law, 1 disclaimer and 2 a public inventory, and there's no doubt that there could be disclaimer if there's good cause, an extension of time. And there's a debate about in the Swiss authorities about whether it's possible for there also to be an extension for public inventory. And then finally, paragraph 8, I just invite your lordships to read that. But that's the basis on which it's said that the heirs need to be bound to the outcome of these proceedings. And none of that's an issue, my lady, my lords. But it's notable that, as it were, there are still steps to take in the Swiss, or rather, there are steps that could be taken and rights belonging to the heirs in Switzerland under Swiss law, which would be open for them to be taken. Most notably, they need to decide whether or not they're going to disclaim, or rather, if they're going to seek for an extension of time within which to disclaim. And
Which
they-
is slightly different. I mean,
Exactly.
the time for claiming or disclaiming has passed. The question is whether they could seek an extension of that time, given that a considerable time has now passed
Exactly.
since the death.
That's right. But they would need good cause, as Professor Jacob says. But, for example, the fact that they don't know whether they are going to inherit very substantial liabilities or a large amount of money may be a good cause. We just don't know. Similarly, with the public inventory, they can seek to extend time to obtain a public inventory.
But it's uncertain whether one can.
It's uncertain whether one can jurisdictionally, and it's uncertain whether they get one, because they would also presumably need to show good cause. And the final factual point is that it's common ground that the daughter Fager registered her address under the Companies Act as an address in England for 2 companies of which she was then a director. And that was the company's accountant's address, to which she had no other connection.
What do you mean by then? You mean when she registered it?
When she was served.
And when
I think-
when she was served, she was still a director.
Correct. So I think she has since ceased to be a director, but for present purposes, she was then a director, and there's no point taking that she wasn't a director for purposes of the section. So that brings me to the second section of my oral submissions, which is the judgment and the order below. Looking at the order first, it's at core tab 5, page 63. And you just have to look at the second and fourth recitals, because they show that my client's solicitors, PCBB, confirmed by letter they're instructed to accept service without prejudice to the jurisdiction challenge on behalf of the 42nd and 40, that should be 5th defendants, and the Rajaan, and then later the Rajaan children, having confirmed they agreed to instruct my instructing solicitors to accept service if their jurisdiction challenge was unsuccessful. And that's why over the page, the form of declarations is firstly there was a declaration that Fager was served at the relevant registered address of the 2 companies. Second, and this is not appealed against, the common ground that Fawaz, one of the sons, was not served at his last known address in the UK. But then Farad and Khaled were served with proceedings by service on their solicitors within the UK, but subject to the right to challenge jurisdiction. And then the declaration at 4 that the English court has no jurisdiction to try, has jurisdiction, to try PIS claim against the Rajaan children, and so paragraph 5, the application was dismissed. Now the reasons for that are in the judgment, turning on to page 66 where it starts, but the substantive discussion starts at page 77. So you'll see at page 77, paragraph 41, the familiar test from AK Investment about necessary or proper parties, and then a summary of some of the other authorities at paragraph 42. And again, that's all completely common ground, and we accept that that is the test. And then at 44, you'll see that he his lordship referred to the first route which Mr. Norbury relied on, namely the court will be in a position to determine the heirs of joint and several liability, is by no means straightforward. And then if you just read on, you'll see that he says 44 and 45, effectively it's very complicated and he'll deal with it at trial. And then at 46, he says that's not the end of the argument, because there is also Mr. Norbury's alternative route, i.e. that it's important that the heir should be joined to the present proceedings in order to ensure they're bound to the result of the case, that Mr. Rajaan and now his estate as a significant liability to PIFs. And so that double formulation of the submissions follows, as it were, the pleading we've seen. And then at 49, he says, it follows, in my view, that there is an issue as between Piss and the heirs as to whether, in fact, there is a liability on the part of the estate to Piss, i.e. the very issue that's determined in the forthcoming trial. It's also clear that the heirs have not given any indication, let alone any undertaking, that in the context of enforcement proceedings in Switzerland or indeed elsewhere, they not take the point that the issue of liability had yet to be determined against them. Crucially, of course, I'm not sure it's against them, it would be against the estate, but be that as it is. And then over the page, you'll see at 52, His Lordship said, it does seem to me that in circumstances where the heirs are in any view closely associated with Mr. Rajaan, and where there is a prospective enforcement against assets in Switzerland which would otherwise belong to the heirs, there is every reason why it is necessary and proper for them to be joined as parties to the present proceedings so that they are bound by the result. I think that's the bit I emphasise. They're being joined to be bound. And then if one goes on to...
So on this footing, there wouldn't be judgment entered against them. It would simply be, in effect, a declaration that the estate is liable.
Well, it's not at all clear what it is that His Lordship envisages, because if there is no claim being advanced against them except as necessary proper parties, and for reasons that I'm going to try and develop, my Lord, there will be no order against them, because the English court on my submission cannot make an order against foreign law successors. Now, the declaration, as it were, that the estate is liable, that's a declaration that doesn't require my clients and parties. And it's,
But if you want, as the judge wanted, your clients to be bound by it, then they do have to be parties.
But, my Lord, as I say, if the purpose of that declaration is to say, as pleaded in the 12A, that either a finding of liability under subparagraph A of 12A, so that they do succeed to the liabilities and are liable, or B, enforcement of a judgment, what does B look like? What order is it that's made against my clients? If they're just on the as it were, header of the judgment, there's no declaration or order against my clients. Therefore, on my submission, they're not proper parties. What are they doing there? And that's quite apart. I'm sorry, my Lord. That's quite apart from what I say about, obviously, the jurisdictional gateway. I completely understand the gravamen of what my Lord is saying. You know, why not just join them? Then they're bound. What's your problem? I can put it colloquially. But my problem is, apart from the fact that I say the court has no jurisdiction just to reach out into foreign law successors, join them. It's a brute and full. There's nothing going on. There's no judgment against them. There's no order against them. What is it that the order is doing?
Well, to be clear, you're not instructed to offer any undertaking that your clients would accept the determination of the English court as to the liability of the estate.
Well, that is right, my Lord. I think what I would say, though, is that it is irrelevant what my clients do or don't accept insofar as it applies to the English estate. They can't accept or otherwise liability against the English estate. That's Miss Al-Wazan's job. What is actually being sought is an undertaking that my clients will accept that effectively they are personally liable as successors to the judgment debt in a foreign jurisdiction, or in fact across the world.
No. You're not being asked to accept that at all. That would be a question which arises in the context of enforcement. All you're being asked to accept is that you won't require the issue as against the estate to be relitigated a second time.
But again, my Lord, the issue against the estate, there is an issue against the English estate. There is no Swiss estate against which for there to be an issue. So, my clients have no position to take on the litigation against the English estate. The English estate will be bound by the outcome of these proceedings one way or another. My clients, they don't. It's not clear to me what undertaking or formal statement they could make in respect of the English estate.
Very simple. They could accept that the English court's determination as to the liability of the state is one that they will respect
My lord,
and not required to be relitigated.
my lord, again, when you say the estate, do you mean the English estate?
To be sure.
Yeah. Well, my lord, I will take instructions on that, but I don't know, but I may be able to answer my lord's question more directly, because our problem is not liability against the English estate. The English estate is constituted, it's going to be bound, the consequences that follow from the liability against the English estate will flow. What my clients are concerned about is liability in Switzerland, or the Bahamas, or France, or anywhere else which would follow if they are named defendants and an order or declaration is made against them personally.
Just so I understand it, Mr. Sherwin, if this, putting that aside, the bottom line is that you're suggesting that in order for the children heirs for there to be any liability in relation to the Swiss estate, of which the children heirs are communally heirs, both as to assets and liabilities, you're saying there has to be, in effect what you're saying is, there has to be a new action in Switzerland, are you? Which does what precisely? I'm trying to separate out, because you are using this English estate label very liberally, but what are you saying that therefore needs to be done in Switzerland to make it a Swiss liability?
Well, my lady, the short answer is
I'm sure it's got to be take very big, small steps, but
Yeah.
it just seems to me that we have a bit of a disjunct here.
My lady, I accept that. So, obviously there will be judgment if, on the hypothesis that D1 is going to lose, as it were. There will be judgment against D1, and D1 is the English estate. And when I say
and D1 is the person representative in relation to the English estate, which we all accept has
Yeah.
to be administered, etc., etc.
yes, so that will then create a final and binding judgment on the English estate. And so one then, as it were, sets the words English estate aside into a box. There is no Swiss estate, as your ladyship appreciates. There are just the community of heirs. Now, what PIFs would have to do in Switzerland would be to bring an action against the Swiss community of heirs, all of them. Now,
And for what? An action which is to show that the deceased was liable
well,
in just the same way as the issue in these proceedings in this jurisdiction are whether the deceased was liable.
yes,
So exactly the same.
yes, except the defendants would be the community of heirs,
Yes.
not any notional
So
estate.
precisely the same, but against what you would say is, in loose terms, the Swiss estate
Yes.
rather than the English estate.
Exactly.
Okay, got
Exactly.
it.
So, and at that point, as it were, whether, as it were, following, before any action is brought, or during the action, the Swiss heirs, children heirs, would be able to choose whether or not to disclaim liability in Switzerland, call for public inventory, or whatever.
Well, they wouldn't be able to choose whether to disclaim. They could choose whether to
Excuse-
apply for an extension or a reinstatement
Precisely.
and then seek to disclaim.
Precisely.
But they might or might not. As the judge said, at the moment we're in a state of ignorance as to whether that would succeed.
Precisely.
So even if judgment for a very large sum of money is given in England, which might exhaust the assets available to the heirs, it's no guarantee that they would be able to disclaim that liability, because we don't know whether they would or not.
I completely accept that, my lord. We are in a state of, as it were, perfect ignorance on that. And I don't say we will be able to disclaim, and so it's just a matter of time. I absolutely accept the thrust of what my lord has said.
Yes. That means there may be circumstances in which the claimant, PIFs, wishes to claim against your clients in Switzerland, and you have are too late to disclaim. So you will be
We
liable.
we lose that extension
Yes.
application. Yes.
So you will be liable if the deceased was liable.
Correct.
That's as I understand how it works.
Correct.
So the issue in those proceedings, if they do take place, is was the deceased liable to this?
Yes.
Is that not the same issue in these proceedings?
It is the same.
It is the same issue. So is it difficult to understand what the judge means when he says that they should be joined as parties to the present proceedings so that they should be bound by the result? I mean, what he clearly envisages is that if you're made defendants to these proceedings, if you remain defendants to these proceedings, his decision on that issue was the deceased liable will be something that you are bound by, in the sense it won't be open to you to relitigate it. That's clearly what he envisages.
My lord, I'm not trying to be willfully ignorant on this. I'm not trying to sort of close my eyes to the reality of what's going on here. I completely accept that that is what his lordship meant.
Because we started this discussion with you saying that you didn't understand what he was saying.
Well, no, my lord,
Maybe that's my misrecollection, but I thought that's what you were saying.
My lord, the point I was trying to get at is a slightly different point. What I was trying to say was that I don't know, as it were, on what his lordship was saying, whether he envisaged an order being made against my clients. The 42nd, 45th defendants are liable to the extent of, however many £1 million final judgment is. Because that would be a very different matter on my submission, to there being no order against my clients, but them just appearing, as it were, on the header of the...
Well, doesn't this go back to the suggestion my lord made earlier? Because, as you rightly point out, there is no substantive relief claimed against your clients. That is common ground. What is sought is a determination of the issue of the liability of the deceased, which is binding on your clients. And I take your point that there is no order in those terms expressly sought, but why could that not be given effect if it were otherwise appropriate by means of a declaration?
What would the declaration say, my lord? That the
A
English
declaration that the first defendant is liable, that declaration being made against your clients. So, I mean, this is simply discussing machinery,
yes,
rather than the real issue which you're arguing. But at the moment, we're just trying to clear the decks to see what's something that we need to focus on and what's something that perhaps is less important. Because while you're undoubtedly correct to say no substantive relief sought, it doesn't mean to say that the court is powerless to make a meaningful order, does it? Because it can make a declaration. And that then takes us to the real question, which is it appropriate for the liability of the deceased to be determined as against your clients in this jurisdiction?
Yes, my lord, I completely accept that, and I'm sorry I took the panel down a blind alley, as it were, that if it was thought that I was suggesting that, as it were, that I didn't understand that was where we were getting to, and that is indeed obviously the reason that the judge below bound or thought he was binding my clients. He wants them to be bound to the outcome, whatever the outcome is, as it were. And the reason,
and of course, it could be favourable to your clients. I mean,
absolutely.
If the conclusion of the English court is no liability,
yes,
that would be to your client's advantage.
it would.
And in fact, that's got nothing to do with the English estate or not the English estate. That the issue, and the question that I asked you before, and my Lord Justice Nugee asked you, the issue is, was the deceased liable?
Yes.
And so that isn't asset immovable or not movable based at all. It's about, was the deceased liable, and your clients being bound by that conclusion, whether it be yes or no.
Yes. Thank you. Now, what the judge below, the reasoning the judge below gave is that, so paragraph 53, I don't have to take you to this in detail, your lord, my lady, my lords have this point, it's the point that my Lord Justice Arnold made. Paragraph 54, it does not seem to me there's any authority which is to contrary effect. And then the final sentence, there is also no authority which suggests that simply because one defendant is the correct defendant for the purposes of the claim which is being made against a person in the present case, Miss Rajaan is clearly a correct defendant in relation to the claim which is made against Mr. Rajaan's estate, is therefore impermissible to join another party as defendant. And that is the guts of the appeal, isn't it? That can you never be a proper party to in such circumstances? And then the judge identified
your case. Sorry to interrupt, but I mean, as I understand it, your case is fairly straightforward. You say there is only one proper party to this claim. It's the personal representative of the state, because that's the whole point of the machinery.
Exactly.
You say that's why she's been appointed. She's properly in post as administrator to represent the estate, and that's the end of it. And you say, therefore, nobody else.
My lord, that's precisely right. And the therefore, in what your lordship says, is, I think, the whole issue between me and my learned friends, which is, does that follow?
Yeah.
And I obviously say it doesn't, and I hope to show why that is. But just before we finish on the judgment, paragraph 55 identifies the three analogous jurisdictions that the judge below identified. So we've got Chabra, we've got Rule 19.13, and we've got the assignee or assignee issue, if I can call it that. I don't think we have to go through that paragraph in detail. And then paragraph 56 is the point that I think everybody on this tribunal, but I'm going to point to my Lord Justice Nugee in particular, the point that you were drawing out earlier, my Lord, the point that it is, quote, sensible and appropriate, picking it up from the third line down, in my judgment, to take steps to ensure the heirs are bound by the result of the court's decision, so as to present a situation arising where the claimants have to argue the entirety of the case, again in a different jurisdiction, in order to establish the core underlying liability, which on this hypothesis they've established in England. And so I completely accept, my Lord, that that's what his lordship was doing. And my steps that I'm going to hopefully now develop now are trying to make good my point on the whether or not it follows or whether or not it's a non sequitur on the necessary or proper party test. I completely accept that that is what I have to convince my lady, my lords about. And I'll just flag for completeness at paragraph 60 is where you've got the section 1140 point, but the judgment effectively was that is beyond argument at first instance and that it doesn't matter anyway. So that is what it is. So that brings me then to the...
Yeah, it doesn't much matter, but can you help us on this question? On the face of it, there's a slight oddity in the sense that in paragraph 60, the judge says it's unnecessary to resolve the issue of 1140, and yet he makes an order on that basis, which seems odd.
Well, I mean...
I mean, in a sense, it might be thought that what he's really doing is he's simply saying, well, I'm going to follow the existing first
I think that's
authority.
I think that is what he's saying. I mean, when I stood up, you'll see this in the transcript, I don't think we need to go to it. I said, we've got this point, and he said, I'm not going to listen to argument on that. That is now subject to a long line of first instance authority. It is beyond argument for first instance, and you have to go to the court.
Right.
And so that I absolutely accept that what I have to convince you on section 1140 is that line of first instance authority decisions is wrong, right. And that he did make an order in the terms, as it were, that you've seen.
All right. Well, that makes sense.
Are there any practical consequences if obviously if your appeal succeeds,
yes.
then we have to address this issue.
Yes.
But if the appeal fails on the main ground, then does this become moot?
It does become moot, my lord, because my client Phaedra will accept the consequences of the failed appeal on ground one. Yeah. Yes. I mean, there's an interesting question, I suppose, as it were, if I win on ground 1 but not on ground 2. But in answer to my lord's question, if I lose on ground 1, it is moot in the most pure sense of the word. There's no, your lordship doesn't have to decide it.
Sorry, ground 1 being
Being succession. If I lose on that, she is going to be bound because she accepts that she will be a proper part, and she will accept that she is.
okay.
Does that? I might have lost you, my lord, when I was.
No, it's right. That's fine. Thank you.
So that we finally come, my lord, to my ground 1. Now, the ground is at page 15 of the bundle. I don't know if your lordships want to look at it. I mean, I think we all know what it is. Namely, that where a personal representative is a party, successors are not amenable to service under rule gateway paragraph 3.13, the necessary or proper party gateway. And I do say that means that they are not and cannot be necessary or proper parties. That absolutely is my submission. But it's my submission they cannot be necessary or proper parties without more. So I absolutely accept that if there is some additional, if they're joined as joint tortfeasors, for example, they may of course be liable. But
You mean purely as successors?
precisely. And I say, as you know, that principle follows from the series of well-established principles that I go through in my skeleton arguments, and they're not in dispute, or they're not much in dispute. I mean, what I'll do is I'll say what they are, and you've read the skeleton argument. I don't think there's going to be anything particularly outrageous about them, but you can obviously push back on me if there's any particular point of further help I can give you on any of them. So firstly, obviously, the law of England distinguishes between the administration of the estate and succession to the assets. And second, the payment of debts is part of the administration of the estate. It's part of the administration phase, as it were. And third, pursuant to section 1.1 of the Law Reform Miscellaneous Provisions Act 1934, a cause of action subsisting against a deceased person survives against the estate, and it's enforceable against the personal representative, including one, as here, with a limited grant. Now, pausing there, it's my next step that is, as it were, is in dispute. This is the first sort of area of controversy. And it's my submission that it follows from those three principles that a personal representative is not only a correct defendant, but the only correct defendant. One cannot pursue third parties who are successors. Now, that's why in a purely domestic context, I say, you do not sue beneficiaries. Because you never get to the succession pursuant to which the beneficiaries will take assets. And beneficiaries they have no fixed interest in an unadministered estate. That's all uncontroversial.
What happens if, I ought to know the answer to this, but suppose a personal representative takes the estate, thinks they've administered it, distributes it to the beneficiaries, and then a claim is brought. It's still brought against the PR, but in terms of enforcement, you do want to follow the assets into the hands of whoever's got their hands on them.
You do, my lord.
And you can do that.
You can do that under the diplomat remedy, absolutely.
Absolutely.
Sorry,
So then you do join in those circumstances.
I didn't catch what you said under.
Under the diplomat remedy, as it's
Yeah.
called. So diplomat is a case from, I think, the 1950s from memory.
1948, I think.
Thank you, excuse me, my lord. Whereby it was said that effectively if a beneficiary under estate obtains assets belonging to the estate, in that case some charities, the claimant can trace the assets in rem into the hands of the beneficiaries, but the purpose of that, on my submission, my lord, was to reconstitute the estate. Because what has happened...
But in those circumstances,
Yeah.
in other words, where the claim against the executor of Diploc's will was going to exceed the amount of assets in the hands of the executor, and indeed his own assets, because he was personally liable, I think, to the extent of the assets of the estate. And you knew, by the time you got to court, that he was not going to be able to meet the judgment out of his own assets. You did join the beneficiaries, purported beneficiaries, as people who have received assets.
Yeah.
I mean, it's not because they were actual beneficiaries, because the whole point of the case was that they were charities and it wasn't a valid charitable trust. So it belonged to the next of kin. But they were people who had got their hands on assets but were liable to the plaintiff. And so there are circumstances in which you sue not just the PR but the people who have got the assets.
Yes, my lord, but what happened there was that the charities obtained the assets, as it were, on the false premise that my lord has identified. So what they had to do was return the assets to the estate, and then the estate could be properly administered on the true footing. It wasn't, as it were, it's like a reconstitution of a trust or similar. One doesn't sort of short-circuit the process of administration. What had happened is that the process of administration was still open. It's just that everybody had wrongly thought that it had closed. And so I completely understand what my lord is saying. He's saying, here is an example of some beneficiaries who were joined because they were, as it were, they had the assets in their hands, and therefore that gets you round, as it were, my bright line law principle. I completely accept what my lord is saying. But the reason for that was not so that they would be bound personally to the outcome of a inherited liability. It was so that we could go back to the previous position, namely that the administration of the estate had to be completed, the debts identified, and either there would be an insolvency or not.
And if I recall, there was a priority, and of course one had to sue the PR first, or be satisfied that he would not be able to make good.
Exactly. So the PR obviously is only liable to the extent of the assets in his or her
And
house.
he hadn't got any.
Exactly. And so then one goes down, and I'll come to this in a moment, Section 1.6 of the 1934 Act.
Yeah, you go down to them.
No, my lady, I don't think you go down to them in the sense that they're kind of next on the list of, because obviously under normal circumstances in an insolvent estate, the money hasn't gone out.
I understand.
Okay.
I'm sorry, that was a loose one.
And that is what Rule 19.12 on my submission is doing. So it says that the claim must be brought against the personal representative. Now, I mean, we can look at 19.12 if that would help. Yes. Do you have the white book? It's also in the authority manual, whichever is useful. So, White Book Volume 1, page 569.
Five, 6, 9.
569.
Yeah, you're probably looking at an out-of-date one. We don't have up-to-date ones.
Yeah,
I'm
sorry.
sorry.
It's in your
So
authorities
19.12.
bond.
I'm sorry, I hadn't noticed that it's ridiculously out of date.
No, I'm very sorry.
No, don't be sorry. It's not your fault. 19.12. Yes.
Yes. Now, my lady, it might be so out of date that the rule has changed. It used to be Rule 9. Does it start where a person who has an interest in a claim has died?
No.
Oh, right.
So it's tab 3 of the authorities
Thank you.
bundle.
I'm sorry.
Exactly. Let's give up with that.
And it's at page 14.
Thank you. I'm sorry for that delay.
And you'll see
Yes.
that number 1, where a person who has an interest in a claim has died and that person has no personal representative. So that's not us. But if under those circumstances, you either proceed in the absence of a person representing the estate, or you appoint a person to represent the estate. Now that is us, as it were, prior to the grant. So that's why I said that Ms. Alwan was originally appointed under Rule 19.12. Then you have where we are now, which is where a defendant against whom a claim could have been brought has died, a grant of probate or administration has been made. The claim must be brought against the persons who are the personal representatives of the estate, of the deceased. So again, must is the key word for my purposes. Or B.
Well, I take that point, but I'm not quite clear why we're in this scenario, because this applies where a defendant against whom a claim could have been brought has died.
Yes.
And this is not that case. The claim was brought. against the original first defendant before he died.
Yes.
So isn't that why we're in paragraph 1 territory?
We are in paragraph 1 territory, my lord, but what I say is that one can see from subparagraph 2 that as it were, one can read back into subparagraph 1 that where you have a personal representative, once a personal representative as were exists, you must bring the claim against that personal representative. Because paragraph 1 is on the premise that there is no personal representative appointed, and that person has no personal representative the court may order. So it doesn't admit of the situation where there is a personal representative, which is where we are now.
Well, I understand the point you're making, but in terms of what actually happened in this case, was the original first defendant died
Yes.
during the course of the proceedings, and an order was made by Mr. Justice Henshaw appointing a person to represent the estate.
In fact, Mr. Justice Jacobs, but yes.
So,
But then the grant by Mr. Justice Henshaw comes in, and once the grant exists, as it were, I say that it had to be the personal representative. My lordship is furrowing his brow.
well,
Is this not
sorry, why is not the relevant order? You mentioned Mr. Justice. Oh, I see.
Yes.
Right.
Yeah. I'd like to have a local referendum.
I was wondering if this was a case of substitution of parties, because the claim was properly brought against the deceased when he was alive.
Yes.
I mean, sometimes people sue people who are already dead, which causes its own problems. But he was alive when he was sued.
Yeah.
He then dies. His liability passes to his PRs
Yes.
in England, and they have to be substituted.
Correct.
And I think that's a different rule. I'm not sure.
Well, it might be, my lord, but my point is that when you say they have to be substituted, it's that mandatory aspect that I'm trying to focus on, my lord. Because I say you have to sue the personal representatives. If there are personal representatives, you have to sue them. And that's the effect of section 1.1 of the 1934 Act, because the claim subsists against the personal representative. So you can't join, again, to use flippant words, Tom, Dick or Harry, you join the personal representative. Now the question is not, this isn't a question obviously about Tom, Dick or Harry, because only if Tom, Dick or Harry are beneficiaries or successors would anybody want to sue them. But if there is a personal representative, I say the effect of section 1.1 of the 1934 Act, as mirrored in this, is that you sue the personal representative. There is an obligation to sue the personal representative.
You would say because the claim which was brought against the defendant who has died continues to the extent that it continues against his estate.
Yes.
And his estate is represented by the personal representative.
Exactly.
End of story.
But it's slightly,
That's what you would say.
it's slightly stronger than that, I think, my lady, because what section 1.1 of the 1934 Act says is that it subsists against the personal representative.
Yes, exactly. But I was
It's-
just trying to analyse it in that way, in the sense that what happens to that claim once the person dies. And he would say the distinction is it's against his estate, it's not against his individual beneficiaries.
Exactly.
Right, but sorry to be banging my head against an irrelevance, probably, but I'm still struggling to understand what happened in this case and how it fits into the rule. Because at the moment, it seems to me what actually happened in this case, and I was grateful for your correction earlier, as you said, Mr. Justice Jacob made his order in 2022, and at that stage, the deceased wife was a party, as you pointed out. She was not an administrator of the English estate at that date. and therefore she was appointed pursuant to 19.12(1)(b, as it now is.
Exactly.
She was appointed as a person to represent the estate.
Exactly.
Because that rule is not limited to those who are administrators.
Yes.
You could appoint, for example, a solicitor to represent the estate. And then what happens subsequently, by virtue of Mr. Justice Henshaw's order, is she is then also appointed as administrator of the English estate.
Yes.
And that's perfectly logical, and it could have been the other way around, but
Yes,
it wasn't.
It wasn't. But what I say is that once and obviously that because it was the same individual, Ms. Al-Wazar, it telescopes the process. So nobody thought, do we need a substitution order? What's the juridical basis of this change of as it were? But had it been two separate people, had there been a Rule 19.12b person, and then a second person, again, for example, a solicitor had been appointed, what I say is that that solicitor would have had to come in and replace Ms. Al-Wazar because they are the personal administrator. They are the person against whom the claim must be brought, whether pursuant to Section 11 of the 1934 Act or otherwise.
But that's the bit I don't get. Because if an order has been made under 19.12(1)(b,
Yes.
and subsequently a different person, as you're hypothesising, is given a grant of administration, you seem to be suggesting that somehow undermines or displaces the extant order, and I don't see why.
I don't say it undermines, my lord, because obviously for the purposes of the English litigation, what this rule does is it says this person represents the estate. But for the purposes of the law, as it were, on liability, where liability is against the person representative, it is against the estate, I say that it would be very hard, or I would say it would be impossible, for the person appointed under Rule 19.12(1)(b) to resist, as it were, being substituted by the person representative, because that is the person against whom the claim subsists as a matter of law.
Well, I can well understand if what you're saying is that upon an application by the duly appointed administrator of the English estate for substitution, the court would make the order, no doubt. But what interests me at the moment is what happens if there's no such application. I think I've understood you to accept that if there's an order under 19.12(1)(b, that can continue through to judgment.
It does, but there will then be a question about whether or not that judgment is as it were, enforceable against the person representative. Because the person representative isn't joined. You've got your judgment against, person B, if I can call them that. But that's just a judgment against person B representing the estate. The person representative will say, well, I wasn't involved in this. So that's why I say that the mandatory force in sub-rule 2 and under the 1934
But
Act.
it doesn't apply. This is what I'm struggling with. Against whom a claim could have been brought. It doesn't apply if there's an extant claim that has already been brought.
Yes. But only if there's not a person representative, as I say. And I think my lord might be right that if there is a person representative, that person comes in to be substituted.
I think it's 19.2 which applies to change of parties generally.
Yes.
And the court may order a person to be added as a new party under 19.2. It's 2.4. May order a new party to be substituted for an existing one if the existing party's liability has passed to a new party.
Yes.
So, in a case where there's no PR when the
person dies.
when the person dies, you can get an order under 1912, which was done.
Yes.
But once a PR has been appointed, your point is the liability then is now enforceable against that person, whether they're an administrator or ad litem or an executor, because the whole point of appointing them as administrator ad litem is that they become the correct defendant to defend the proceedings. At that point, they should be substituted.
Exactly.
And they were substituted in the sense that instead of it being against Mrs.
How was that?
Thank you. under 12.1b, it became her as administrator ad litem.
Yeah.
We don't need to answer the question because it doesn't arise. What happened if she hadn't been, if she'd have been appointed administrator but not been substituted?
Yeah.
Because, well, it might cause difficulties, but it's not our
But
case.
I say that under those circumstances, she had to be appointed because, to use your lordship's 4A, the existing party's liability has passed to a new party.
Well, whether she had to be or not, she was.
Yes.
And so we've ended up with the situation in which she is now
a party.
the correct defendant.
Exactly. Pursuant to the two grounds.
Yes.
Now that brings me then on to the key authorities on my submission, which are firstly the High Commissioner for Pakistan against Nat West case, which is at Divider 13, page 121. Now, if we start just at page 122, paragraph 3, what you'll see is that this was a CMC in front of, I think it was a CMC in front of Mr. Justice Henderson as it then was, and you'll see from paragraph 3, he talks about the benefit of appointing a properly constituted personal representative to solve the procedural points, and he refers to the 8th Nizam about the need for a properly constituted personal representative. What has happened is that the 7th Nizam has died, and there's then a dispute over how one binds his estate. And then one goes on to page 124, paragraph 17, and you'll see that he appoints a administrator ad litem and collegiate bonner of the 7th Nizam. So that's what he does. And then over the page again, paragraph 23, you'll see that the Nawab Khan, who is an heir of the 7th Nizam's estate, seeks to be joined. I'm not prepared, he says, to accede to the application that he should be joined at once the proceedings in a representative capacity. Insofar as he claims as an heir to the 7th Nizam, he is, in my judgment, in the same position as all others interested in the estate of the heirs. They can and should be represented at stage 1 by Mr. Lintott in his role as administrator. So his point there is that he's not going to join the heir because the administrator is there. And then over the page, at the bottom of the page of paragraph 27, you'll see that the counsel for the Nawab had said that he can claim directly against the father because he is an heir. The argument was put briefly that he would be able to rely on the Muslim personal law applicable to the succession of the 7th Nizam's estate, and you'll see just over the page the evidence in its current limited form, etc., indicates that the relevant property would have vested automatically in his heirs. So it's the same sort of automatic vesting as one gets under Swiss law on the face of this. And then Mr. Justice Henderson of the A1 said at paragraph 28, and I just invite your lordships, my lady, my lords, just to read paragraphs 28 and 29.
There's claims to an asset in England.
Correct. Yes. So, and what Mr. Justice Henderson then was said, the claims must be advanced by or through a personal representative.
Yes.
Yeah. And I say that the same applies mutatis mutandis for defence. Yes. I.e. that in the same way one sues by and through a personal representative, one is sued, as it were, by and through a personal representative if you are the beneficiary or successor, because of this same process of administration followed by succession.
Well, I understand that. How does this work if the asset is in a different jurisdiction, such as Switzerland? Because the reasoning of Mr. Justice Henderson is all based on property in this jurisdiction.
That's exactly right, my lord. So because the personal representative only represents the English estate, only the English assets are the assets that come into England. So when you get an order against the English estate, against the person representative, it stops, as it were, at the border.
Right.
And so if you want to enforce against a foreign asset, you have to go to the foreign country. Now, this was applied in Viegas and Cutrale, a case my Lord Justice Nugee was in. We can turn this up as Authorities 19 by this court last year. Now,
Sorry, before you go on, just so that I'm clear about your position, what do you say would have been the position, therefore, had the deceased in this case not died? And he has assets all around the world, and there's a judgment against him. That would be a judgment against him, which is binding against him, that then, to the extent there were assets here, you could take the enforcement steps that you would, and you can take the enforcement steps that you can in other jurisdictions based upon the judgment in relation to liability which has been gained here.
yes, that is what would have happened.
But when we're looking at a situation in which he has died, your argument is then seeking to restrict the effect of that judgment so that it only ever can cover assets within the jurisdiction. That's the practical effect.
Well, no, my lady, you have to go and enforce the judgment around the world, and you have to take the foreign laws of succession or administration as you find them. In the same way that if you have a judgment against a living person, you have to use the statutory mechanisms, recognition of judgment acts or whatever, to go around and enforce against foreign jurisdictions.
And you say the fact that in this situation in Switzerland you would actually have to prove liability again is just one of those things.
My lady, it is what it is. Foreign courts and foreign jurisdictions are entitled to come up with their own laws for operating succession. Now,
You just say that's one of those things.
Absolutely, and we have two broad ways of doing it. We have, as it were, our way, if I can put it slightly chauvinistically, which is administration followed by succession. And we have the civil law mechanism.
Yes, I understand.
Well, indeed so, and that's a very proper point, but it leads to this question. Let's pursue my lady's hypothesis.
Yes.
So let's assume that there have been not only had he not died, nobody thought he was going to die, and the claimant was looking ahead during the course of the proceedings to what it was going to do about enforcement in Switzerland. But thinking, well, by the time we get to enforcement in Switzerland, maybe there is a risk that he would have died. So thinking ahead, they say to themselves, okay, what we want to do is to get the judgment binding on the potential heirs. So they join him. They join the children at that stage while he's still alive.
Yeah.
Could you have resisted that?
I say yes, because they're certainly not necessary parties.
Okay,
Are
but
they
why are
not?
they not proper parties?
Because my lord, they have no liability. There's no theoretical possibility of liability unless they become the heirs. And what you're doing there is you are bringing to the English court a question which is purely for the foreign court to consider who the successors are, who are going to be the heirs. And one only knows that on death because you have testamentary freedom or you have forced heirship provisions. And those are all matters that are governed by the foreign court in its foreign probate and succession jurisdiction. And so effectively, my lordship's hypothesis is that anybody could be joined because anybody would be a potential heir. Now, you can obviously narrow down who the likely or the more likely classes of people are. For example, in forced heirship communities, you might be able to say, well, there's going to be forced heirship there. But what my lordship's point is that effectively the narrow or proper party gateway becomes an endless opportunity for the English court to bring to itself potential heirs under any system of foreign law. And actually, I say that there is no difference between before or after death, because one does have a situation, whether one is dead or not, that in order to, as it were, short-circuit the process of going to the foreign courts and establishing liability against each of the relevant community of heirs, or a Bahamian PR, or whatever. One just adds them to the English court, as it were, willy-nilly, and says, great, well, we've got liability and we've covered off everybody. And we're not going to get orders against them, my Lord and Justice Nugee's point. They will just be a declaration of liability and they will be bound on the order. And I say that not only is there no jurisdiction to do that, as it were, there's no gateway, there's no equivalent to Section 37 of the Senior Courts Act that says, it is just and convenient to do this. There's nothing like that. That would be contrary to what the words necessary or proper party means, as defined in the AJK investments case. Because there is no cause of action against that. There's no issue there. And I actually completely agree
Is
with
it your submission that a cause of action is required?
No, it isn't, my Lord. I don't say that. But I say that the problem with my Lordship's hypothesis, as it were, is that it creates a completely open-ended opportunity to just add in foreign people who may or may not be heirs. Is that my lady laughs?
No.
Am I being dramatic?
No. I can quite see.
I think that is because I think there is a floodgates type argument. I appreciate that floodgates arguments are sometimes the sort of last resort of the needy, but I do say that there is a severe floodgates argument here, both before and after death.
Can I try and... one of the ways in which you formulated your argument is that the English court is not concerned with succession, so but only with administration. But picking up on one of your examples, suppose that there was a property in the Bahamas,
Yes.
and that under Bahamian law, an administrator had been appointed
Yes.
to administer that property.
Yes.
So we don't have any question of succession. We know who is liable in respect to the Bahamian estate. It's the Bahamian administrator. Could they be joined to English proceedings? So this is a question of, this has got nothing to do with very succession or administration. It's simply the English court won't have anything to do with assets abroad. Is that right?
Can I make that submission good, my Lord? This is absolutely right, and I'm very worried about timing, so I might have to leap ahead somewhat. But can I deal with that point foursquare? Because I agree with my Lord, that is the point. So could you go to divider 22, and specifically page 465.
My lords, just before my own friend does, I just wonder if the transcriber needs a break for a few moments.
I'm afraid we don't have time.
Okay.
Authorities 22 page
465.
465.
And you'll see there rule
160.
160.
Yes.
And that is precisely the point, my Lord. You cannot do it because this, and if you read paragraph 2704(2), a foreign person or representative cannot be made liable in England for property held or acts done by him or her in his or her character as foreign administrator. This is so even if he or she acknowledges service and submits to the jurisdiction. Now, the case that my learned friend handed up to you, the de Gazan and Barclays Bank case, that was actually a case where the defendant, foreign personal administrator, was actually in the jurisdiction. It was an English bank. And then it goes on, has no power to submit the assets he or she holds to the judgment of the English court. Even a foreign ancillary administrator cannot, it would seem, be sued by the English domiciliary administrator merely because he or she sues in England and is in control of the net balance of the deceased assets. This is explicable on the ground that he or she must be responsible in the country where he or she has been appointed administrator and should not therefore also be liable in England. So, my Lord, I completely adopt, obviously, this, and I say this applies not only to an administrator in the Bahamas or the BVI or wherever. This has to apply to the person who is being treated as administering the assets for English characterisation rules in a foreign civil law jurisdiction, because otherwise the distinction between civil and common law jurisdictions means that you can't sue foreign personal representatives under English style laws, but you can sue foreign successors under civil law jurisdiction. And I say that that is not a permissible distinction to make. There's no authority that supports it, but it's just wrong in principle, because the reason for this rule is that they have to be responsible in the country where he or she has been appointed administrator. So you do, my lords, my lady, have to go to the assets, because it is for the foreign court to deal with the assets and succession to those assets or administration of those assets as it wants. My lord, while we're here, it might be worth looking at the Dagazon case that my learned friend handed up, because it is a stark example of that. I'm very grateful to my learned friend because I have other authorities on this point. He quite rightly located the Court of Appeal authority that's most recent. And you'll see...
And we have the most recent version.
Yes. Well, the most recent iteration of this principle,
Yes.
if I can put it, yes. Yes. So this is a case, it's a judgment of Lord Justice Carr. And what happened was that a former president of I think it was the Dominican Republic, Dominica, thank you, had been ousted and he'd come to England. He said, provided professional services in that jurisdiction to a deceased person, and he wanted to get the money for that back. So he sued the Dominican personal representative in England, because the Dominican personal representative was Barclays Bank International Limited, based in England. He was based in England, and he was going to get legal aid to do that. He wouldn't have got legal aid, he said, in Dominica. Now, the Court of Appeal flagged the point that I'm now developing, which was then Rule 133, I think, but it's now Rule 160 in Dicey. And if I can just pick up the judgment now at page 22 of the report. So you'll see in page 22, column 2, under the law, you'll see the rule I've just read out to you from the current edition of Dicey. And if one then goes over the page to column 1 on page 23, does your Lord... Yeah. Could you just read from broadly speaking, please?
Down to the next heading.
Down to the rule upon which. Thank you. So what his lordship is saying there, Lord Justice Carr, is saying that this rule is a hard rule of law. You can't go through the administration gateway as it then was. I think it's now gateway 30. Because you cannot sue a foreign personal representative in England. And if you just see over the page, on column, the very top of column 2, what his lordship says there, picking up from the second line, although the reports of some of the 19th century cases, and I've got some of the 19th century cases, but we don't need to go to them, are somewhat obscure and unsatisfactory, the existence of the rule was not challenged on behalf of the plaintiff, and in light of the jurisprudence, such a challenge has been unrealistic. So this is beyond challenge at the Court of Appeal level on my submission. And then he quotes from there's a number of Canadian decisions that are looked at, but I don't need to go to those, because what they are just authority for is that the same principle has been applied in Canada and Australia, and the rationale for it is as stated in Dicey. The English court does not seek to interfere in the administration of foreign estates, or put another way, the foreign estate administration is a matter for the foreign court. And now, my lady, the way as you understand, the way I put my argument below, I only touched on this very lightly in front of Mr. Justice Jacobs, because what I was saying was effectively the argument I was developing in front of your Lord, this panel this morning, which is that as a matter of first principles, as it were, where you go through administration and then succession, so administration first, the debts are all dealt with in the process of administration. So if the claim is a bad claim, it goes, and as my Lord Justice Arnold said, that's great for my clients, hooray, but it's great for everybody. But if the debt claim is a good one, it transfers into a debt which is payable in the process of administration. The debt is either then paid or it can't be paid, and we go into the insolvency process. And Section 1.6 of the 1934 Act, you'll see in my skeleton argument, mandates that is a debt provable in the administration of the estate. So you never get to succession. That's my submission.
That's the administration of the English estate.
Correct.
Yes,
But you-
but this point is a separate point, which is if you've got an estate abroad,
Yes.
the English court has no business dealing with it.
Exactly. And this is, I say, a hard rule of law arising as a result of that. So I say it's the other side of the coin. Because the English court cannot, there is never going to be a succession for English law purposes. And the English court only ever looks at the English estate. It doesn't go looking around at foreign assets. Then you can't join foreign law successors. But the obverse of that is, as my lord says, not only can you not join foreign law successors, you can't join foreign law administrators, because the English court doesn't go around adding in foreign people because they're administering the estate under a foreign law rules. And so what Mr. Richardson says in his Respondent's notice is that the unitary nature of the Swiss law, civil law rules on succession, effectively renders the children heirs as the foreign administrators. They're doing the administration from an English characterisation of law's perspective. Well, my lords, if that's right, then this rule applies. And it has to be right, because from an English law characterisation perspective, either their successors, and as I say, they're not susceptible to the English court's jurisdiction for the reasons I've given, or they're administrators, or they're a hybrid. And if they're a hybrid, then I say this rule applies, because otherwise you will start to have the distinction that I've drawn between common law jurisdictions, where you've got to sue the person representative, you can't in England because of this rule, or you, for reasons that are not clear, you can nonetheless bring to the English court the foreign law successors. I'd say that will be contrary to principle and would effectively undermine this rule.
Suppose we go back to the example of a foreign administrator, foreign PR, foreign assets, Bahamian
Yes.
PR. If you're right on the rule, you couldn't sue them in England, seeking to make them liable in England. You couldn't give judgment against them.
Yes. And what happened in this case is that, I mean, because they're in England, it was a foreign non, so the case was stayed against them.
Yes. But could you say it's convenient that rather than the claimant having to prove their case twice, once in England and once in the Bahamas, where it's exactly the same claim, what we'll do is we'll join the Bahamian administrator into the English proceedings, not so as to give judgment against them or bring a claim against them, but simply so that they're bound by the result.
No.
You say that would still be precluded by the rule.
Exactly, because you would be interfering in the foreign administration. Because you would be, as you, the English judge, my lord, would be saying, whatever the foreign law rules about administration or succession or proof of debts or whatever it is, I am now going to short-circuit that process by drawing to the English court the foreign person representative or whatever, and saying you are bound by the outcome of the decision without making it all against it. And my lord, not only would I say that that would effectively cut across this rule and render it a nullity, I would also say that there is just no jurisdictional foundation for that, because you don't have an equivalent of Section 37 of the Senior Courts Act for, as it were, on a freewheeling basis. The Chabra jurisdiction comes from Section 37. It is just inconvenient that ... That's
Sorry, what's wrong with the declaratory relief? Because for declaratory relief, you don't need a cause of action, and the essential basis is that it serves a useful purpose.
My lord, can I invite you to turn up Sanders and... no, I've got the wrong authority. Can I invite you to turn up Aldrich against the Attorney General? This is divider 8. And you'll see at page 40 that what was being sought in that case was a declaratory relief in respect of the estate of a deceased person, that the claimant was the deceased person's father. And the court said it had no jurisdiction to make that because there simply was no jurisdiction to make a declaration against the estate of a deceased person. And I can't...
Yeah, but the law of declaratory relief has moved on an awful long way since 1967.
Well, that may well be right, my lord, but the principles, as it were, for joining a foreign person in order to make declaratory orders, I say hasn't moved on, because in the same way that the rule I've been discussing with the tribunal, that is, I say, a hard rule of law which has stood for many, many years. And so, in order for what my lordship is suggesting is effectively to circumvent that rule by saying, well, we're not going to actually bring the personal representative before the court to make orders against them. And I note that the rule in Dicey isn't limited to, as it were, you can't be brought before the English court except, to be made orders against. It says you just can't do it. You can't bring them in front of the foreign court. Your lordship would be saying, well, I can do it, but just for declaratory relief. But that is still relief for which you are bringing them to the English court.
We've held you up a great deal, and time is ticking. How are you doing?
It is. That's a very good question, my lady. I wanted to take your ladyship through Viegas and Cutrale. I don't know whether it's going to be actually that helpful if I look at it in a great deal of detail, not least because my Lord Justice Nugee was on the tribunal. That was much more of that was very similar to the decision in the Pakistan case that I took the tribunal through. But it was obviously a more developed judgment by Lord Justice Newey. But it's the same principle as I said. Perhaps I could just take you to a very short passage from it rather than going through it in great detail. So page 432 behind divider 19.
Yes.
Sorry, my authority bundle has chosen this moment to explode. 432. So this is in you'll see under the heading analysis of Lord Justice Newey, and in the first paragraph he talks about characterisation and administrational succession, and then he says at paragraph 119 he dismisses the submission that effectively an internationalist spirit would be of any assistance, because it was being pushed on him that by Mr. Chu Choi, counsel for the claimants, that effectively you could just adopt an international spirit and that would help. And then he says at paragraph 120, in broad terms, it seems to me that under the law of England and Wales, matters relating to the collection of a deceased person's assets and the payments of debts are considered to relate to the administration of the estate, and the distribution of assets after that is considered to relate to, quote, succession. As Warrington L. Jane said in Re Lorillard, it is only when the administration is over that the law of domicile comes in. And that's the point that I want to get out of this, which is one is never going to get to succession in this case on any hypothesis. Because either there is no debt, or the debt will be paid, or there will be an insolvency. And so on that basis, that there is just no space for any relief against my clients, whether declaratory or otherwise, because there can be no declaration that my clients are liable to pay any money, or the estate is liable to pay any money. It will either be paid, or there will be a debt provable in the insolvency.
But that's all looking at matters in terms of English assets. As soon as you start thinking about Swiss assets, the position is not necessarily the same.
Well, my lord, yes, but that's where in my development of my argument, I would bring in the principle that we've just looked at. Because I say that when one hits the international perspective, so this is obviously an international case. They were Brazilian claimants, and they claimed as universal heirs the same process we have here. And Lord Justice Newey said broadly, no, you can't do that because you don't have title to sue, because title to sue is part of the English law of administration. So in the exact same way that I say, one looks, as it were, parochially at the English rules to identify who has title to sue. One also looks parochially.
All right, but the point about title to sue is a cause of action has to be vested in that person, yes? And likewise here, for substantive relief against your clients, there would have to be some cause of action that would be cognizable by the English court. But is that in play if one's thinking purely in terms of declaration?
Well, my lord, the short answer is yes, because just as the cause of action has to as it were, subsist in somebody. The defence here subsists in the personal representative pursuant to section 1.1 of the 1934 Act. That is the rule. So the declaration or the money judgment or any other form of relief only goes against the PR as a matter of English law. And one just doesn't look beyond the confines of the island, as it were, because that is the rule of law that we've seen in the Degazon case and Rule 160 of Dicey, which is that the English court stops at the borders. And that just is where we are, man. I completely...
I'm sorry, English courts routinely make declarations which are global.
Yes, my lord, but they don't...
And in a context which is where I'm coming from, which is standard essential patterns, which is a field we don't want to get into today, but it's because of its complexity. But the key point is we make global declarations against foreign defendants purely because somewhere in the mix there's a UK pattern.
Yes, but my lord, one doesn't make declarations, and there are no authority of which I'm aware, and I think the learned friends are in the same boat, where that has happened where in the middle there's an English estate. Because I say these rules bar them. And I say that, as it were, it is a matter of principle if one follows, I say, I completely accept this as my submission logically through the principles of administration and succession. But this panel may be more helped by the rules in Dicey that we've looked at, that effectively say, this is the scope, this is the beginning and end of the English court's jurisdiction. And the beginning and end of the English court's jurisdiction are the assets in England, or any assets that come into England, into the hands of the personal representative. And the obverse of the rule in Dicey is true. Not only can you not sue the personal representative in England, they have no title in England, and that's the Viegas case. So a foreign personal representative has no title to sue in England because they are a foreign personal representative.
So in fact, the way forward says, without delay, in fact, one ought to have done so already, perhaps, ought is a very strong word, might, would have been to commence proceedings in all the other jurisdictions in which there may be assets.
Well, my lady...
In relation to the liability question.
Exactly, because there is a
That's
worldwide...
what you're saying.
Exactly, there is a worldwide freezing order. So the worldwide freezing order, pursuant to section 37, freezes the worldwide assets of the defendant, first defendant, before he died. But they could at any stage have brought proceedings in the foreign jurisdictions. They could have identified the assets in the foreign jurisdictions, and they could have brought them in. In fact, some of the assets from the foreign jurisdictions are being brought into England to pay for the first defendant's legal costs. I think that we've run out of money, but it doesn't matter for present purposes. But yes, if you want to do that, once death happens, you have to go to the foreign courts. That's the consequence of it. My lady, my lords, I appreciate that might not be, as it were, what this court would like, in the sense that one has, as it were, a judgment debtor. One feels that one has to say, well, it would be wrong if the order of this court, made after an absolutely mammoth trial at enormous cost to all the parties, had to be rerun again in Switzerland, and rerun again in the Bahamas, and rerun again in France. I completely accept why that is an unattractive position for this court to feel like it's in. But I do say that that is the only consequence, not only of the principles on administration and succession, but also on the rules that I've identified. I do not shy away from that submission. I completely understand that that is the consequence.
Can I put something else to you? I'm conscious of time. The test for whether somebody is a necessary or proper party so as to enable them to be served out of a jurisdiction is said to be, would they be a necessary or proper party if they were in the jurisdiction?
Yes.
One of the rules, if you have somebody in the jurisdiction, is you can add parties to existing proceedings if there's an issue which arises between you and them,
Yeah.
as well as between you and the existing defendant. That's rule 19.22b.
Yes.
Why can't you simply say, if your clients were in England, you could sue them because there's an issue which arises between them. The issue being not are they liable, because for all the reasons you've said, the English court won't entertain a decision as to whether they're liable qua Swiss heirs.
Yeah.
Subject, obviously, to the respondent's notice. But that, I mean, let's assume that you're right on that.
Yeah.
But on the basis that there is an issue, namely, was the deceased liable to the claimant? And that is an issue which arises, we touched on this earlier, but precisely that same issue arises in the existing proceedings, and it is foreseeable that it may arise in future claims against your clients, whether in Switzerland or in Kuwait or wherever.
My lord, the reason is this. The issue is between PIF's and D1's estate. Okay? So now that's just the first...
You say there is no issue between your clients and the claimant?
There is no issue between my clients and the claimant, except insofar as my clients are successors to the liability. So my lord said you accepted that they couldn't be joined qua successors. But that is the only capacity, that is the only situation qua they would be that issue arises, my lord. Because otherwise they would just be strangers to the proceedings, wouldn't they? Because
but that's what I find difficult, because you accept, and everybody can see, that the logic of your argument is that if the English estate is insufficient, and if a large judgment is given, everybody assumes the English estate will be insufficient.
It is, I completely agree.
Then the next logical thing to do is to go somewhere else in the world. Switzerland is the one we're talking about, but there are lots of other places where there may be assets. With the decision of the English court that the deceased was liable to the claimant already in your pocket. But if we know from Professor Jacob's advice that unless your clients are named in the English proceedings, that judgment will be ignored, won't be of any use.
Well, my lord, no, not ignored, it just won't be binding.
Well, it won't be binding, okay, so that you can force them to re-litigate.
Well, we don't know what will happen in Switzerland, my lord.
Right.
It's a foreign law process, that's the point. You can't break... Look, my lord, can I put it this way? The reasons I say, just summarising them, because we've bounced around quite a lot, just summarising them and trying to distill my submissions in the clearest possible way for the benefit of the tribunal. Okay, why do I say that this inconsistent judgments, enforcement purposes, joinder is misconceived? Right, one, I say it's contrary to the principles we've discussed. Okay, so there's the first, my ground, administration succession. The second ground is the rules in dicey. Okay, you just can't do it. Right, set that aside. Two, it's also my Bruton Fullman point. Okay, which is that the order would either have to be shaped to say that they are liable to this extent, or it would be a sort of freestanding declaratory point. But it would only be a declaration, as it were, against them qua successors. They're only being joined. The only purpose of them being joined is that the interest is an interest between the claimant and the estate, and, as it were, between the claimant and the successors, qua successors. And so, my lord, you can't just say, well, it's not relevant that they're successors. They're just people against whom, it's useful to have a declaratory judgment. It's only useful because they are successors. And once they're successors, they come into the points of principle that I've identified. And so I do say that you can't add them under Rule 19.2 if they happen to be in England, for exactly what happened in Degazon with Barclays Bank, which was in England, which is you can't pursue foreign administrators or successors, successors, in England. And I do say that that is a hard rule of law. So that's my second point. My third point, and it's linked to that, is that the whole process would be to arrogate to the English court the process of succession of all the foreign courts, in which there are assets belonging to the deceased. Effectively, you short-circuit that process. You say, we will deal with that, I'm going to have a declaratory judgment, and maybe I'll have to work through questions of disclaimer, maybe I'll have to work through questions of public inventory, because what if it's raised as a defence? What if my clients say, well, all right then, if I'm joined to these proceedings, I'm going to raise as a defence in these proceedings the fact that I'm going to apply for an extension of time to disclaim. Because then there won't be any potential liability at all. And so you'd have to fight that out in each case. So, for example, if two of my clients are disclaimed, but only two of them haven't, would we have that issue in the English proceedings? And again, that's precisely the issues that the court has sought to avoid by the rules in dicey that I've identified, that the English court doesn't administer foreign assets. That's point 3. Point 4 is that my point that I made earlier, that it would put civil law and common law jurisdiction in a totally different position, because it would be common ground that you cannot do what is now being suggested in respect of the Bahamian PR, or in respect of the fill in common law jurisdiction here PR. But for some reason which is not explained, there is a jurisdiction to do it in respect of civil successors, and I say that is unsatisfactory and contrary to principle. It creates a distinction that could not and should not be supported. Fifth, the orders would be wider than even the orders the foreign court could make, because what this court wants to do, I'm sorry, I don't say wants to do here in a derogatory sense, what this court might end up doing is making a declaration which is worldwide in its effect. So that, let's say my clients are personally liable to the extent of the assets in Switzerland, but there is some other different law in France, or there's a different test for disclaimer in France, or there's a different test in Kuwait, or a different test in California. They are still bound by the declaratory judgment in England in all those jurisdictions. So they would be robbed of the opportunity to fight out all those points, disclaimer, whatever.
Why? I don't understand that. Why are they deprived of disclaiming and doing whatever they want to do? Doesn't affect their ability to disclaim.
Well, I say it does, my lord, because what if it's said against them? Well, they are the heirs. Here's the declaratory judgment. We want to have the money from these people, because again, the reality of this position is that my clients are being joined not because they are heirs in the abstract, because it's suggested that they might have money in one of these jurisdictions against which an order will be enforced. But you do have to go to those foreign courts and work through their local jurisdictional hurdles before one can get an order that they pay that money. And so I do say that it would be a very wide order, because it would be worldwide in its effect against my clients, which is not an order a Swiss court could make, I say. I say the Swiss court would limit its liability to Swiss assets. 6, it means that effectively the consequences that Lord Justice Arnold suggested is that and this is my sort of thin end of the wedge point, either every claimant in a fraud claim would join every potential successor under every conceivable foreign law where there are assets, or you'd have the same thing happening after death, every potential foreign successor. Now, I say, firstly, that would just overwhelm the English courts, but be that as it may. It would also just draw lots of people with all sorts of conflicting rights and duties under the relevant foreign law to have their cases justiciable in England, and it would create an unmanageable satellite litigation. And again, that's why Mr. Richardson's analogy in some ways with an intervener is no good, because by definition an intervener wants to join. These people are being compelled to come to the English court where there is no other locus. And I say that the requirement for PIS to proceed in all of those foreign jurisdictions isn't unjust. First, it's a matter for the foreign courts to set up their own rules of procedure and content. But that's what they're there for. They have that liberty. And the English court, I say, shouldn't ride roughshod over it. I understand my Lord Justice Arnold will say, well, it isn't. It's just making a declaratory judgment. But I say that may and does have consequences in the foreign courts, because they may feel obliged to recognise and enforce that judgment, even though they might not have done it had you started from scratch. And second, it ends up potentially ignoring local foreign law rules, which is why I say the rule in Dicey is there. And that's why I say it isn't unjust to do that. Effectively, when you sue somebody in England, you take them as they are found in England. And the consequences of that is that they might die in England, and you are limited to their English estate. And not to put too fine a point on it, my lady, my lords, that is tough. Those are the consequences of that. And the fact that these rules have been in place since at least the middle of the 19th century, it's only in 2025 that this is being thrashed out in front of this court, I say is suggestive of the fact that you can't do it, that the jurisdictional bar is there for good reason. I appreciate that argument only goes as far as it goes, but that is my submission. Now, very quickly on the 3 analogies. 1, Rule 1913, that is about giving notification of claims in respect of an estate that binds the beneficiaries. My lord, A, that's not a freestanding jurisdiction gateway, and B, it's about the internal administration of estates. It's not about hostile claims, Buckton Category 3 claims. Point 2, the assignor assignee point, that is purely procedural, because here the analogy would be that my clients would be the assignees, right? That they're going to get the liability in due course. And the assignor doesn't have to be bound in those circumstances. It might be bound for principal purposes to make sure that title to sue or be sued is there, but the assign-all doesn't have to be bound. But in any event, it's not a good analogy because it isn't subject to all these rules of law that we've been looking at in the course of today. And third, the Chabra jurisdiction. I've said this point numerous times. Firstly, there's no Section 37 equivalent that just gives this court the ability to make orders, injunctions where they're just and convenient. Second, it is injunctive relief. It is not final relief. And I do say that final relief also applies to the declaratory judgment forms. That would be final relief. Third, it cuts across all the points of principle I've already dealt with. And fourth, even if there were a jurisdiction of the character that we're looking at, the Chabra jurisdiction is tightly confined. So you identify assets that go into the hands of the Chabra defendant, the NCAD, if they're rather inelegantly called, the non-cause of action defendant, and you focus the order on those assets. Now, they might then go out of their hands, except they don't have to have assets in their hands, but these are tightly focused orders that are made pursuant to a specific statutory jurisdiction, and they are injunctive, not final in effect. And so I say that analogy doesn't work. So pulling all those points together on my ground one, I'm sorry I'm doing this rather at top speed, I say that for those reasons, the children heirs, I say that it must be common ground, they're not necessary party. The only necessary party is, or possibly, I accept what my lord said, maybe a Rule 19.12b defendant, but we don't have to worry about that because we have a PR here. Two, there is no issue to be tried against them. I accept what my Lord versus Nugee said, which is that there is an issue, but it is an issue that arises qua successors. It isn't just a freewheeling issue. And if that's right, if it's an issue that arises against them qua successors, then what comes into the rules we've looked at, that you can't bring foreign administrators or those administrating a foreign estate into the jurisdiction of the English court. And I say that England isn't clearly or distinctly the most appropriate forum, and that's, as it were, the flip side of my submission about how England shouldn't be arrogating to itself the foreign jurisdictions that govern succession or probate of foreign estates. So for all those reasons, my lady, my lords, I do say that the appeal on ground one should be allowed, and that the order should be set aside on that basis. Both as it were, the sort of for enforcement purposes, but also the kind of pure basis. I hope that has been a helpful, if somewhat breathless, drawing together of strands. As I said at the start of these, hang on, I'm just going to turn around if I may. I'm going to be much shorter on section 1140. Not least because
that was naughty. I mouthed good in the sense that only in the sense that the timing, and also was inappropriate in every respect, because of course we have asked many questions. So well, thank you.
I'm most grateful, my lady. But I think even if I hadn't had that helpful indication, I think it is quite a narrow point, and I'm going to deal with it quite narrowly. So I'm not going to look at the ground. I think we all know what the ground says or what its gravamen is. So could we look now at section 1140, which is to Authorities 5, page 18. And so just working through the section, the relevant parts are subsection 1. A document may be served on a person to whom this section applies by leaving it or sending it to person by post to the person's registered address. So that's the pure service point. Then subsection 2a, this section applies to a director. And I said to my Lord Justice Nugee earlier, it's accepted that Phaedra was a director at the time. Subsection 3, and this is the key section. This section applies whatever the purpose of the document in question. It is not restricted to service for purposes arising out of or in connection with the appointment or position mentioned in subsection 2. That is to say, it's not restricted to services for the purposes of the person in the servee, as it were, being a director or secretary or whatever, or in connection with the company concerned. So just if one pauses there, that is obviously a very wide subsection, which gives effectively the service for whatever the purpose of the document in question. But then turning over the page, subsection 8, nothing in this section shall be read as affecting any enactment or rule of law under which permission is required for service out of the jurisdiction. So I say section 8 cuts down on subsection 8 cuts down on subsection 3 so that it doesn't create a freestanding provision for service out of the jurisdiction.
But if you serve at an address in the UK, you're not serving out of the jurisdiction.
But you are bringing somebody who would not otherwise be susceptible of service into the jurisdiction. So somebody who would otherwise require to be served out.
I see.
Because subsection 8 has to have some content, by the way. Because if that were, I mean, I'm not saying that's the beginning and the end of the argument. Absolutely, there's several more stages to go through on the authorities. But if that were all that the argument were, as it were, that subsection 8 doesn't stop there being service out because subsection 3 is very broadly cast, subsection 8 would be a complete dead letter.
That's not necessarily, because one of the points made in the authorities
Yes.
is you don't have to register a UK address. You
Yes.
could register an overseas address.
Absolutely.
And if you register an overseas address, subsection 8 plainly prevents you from using the overseas address for service without first having established a right to serve out.
Absolutely. But I say that's not what subsection 8 says. So taking it in stages, there are sort of two limbs to this argument on my submission. The first is that I say subsection 3 is not a specific provision that gets around the rule against there being no service out absent a specific provision. So just look, we can do this by reference to my skeleton argument, which is in core bundle, page 30. And at paragraph 53, you'll see the relevant rule of law. And this is common ground between me and my learned friends that this is, as it were, the applicable rule of law. There is a general principle of the common law that, and these are the key words, absent a specific provision, as in the rules of service out of the jurisdiction, the courts only exercise jurisdiction against those subject to, i.e. within the jurisdiction. So we need a specific provision that brings those not subject to the jurisdiction, i.e. without the jurisdiction, into the jurisdiction. And my submission is that subsection 3 is not that provision, because it does not...
So would you accept that that principle is only applicable where the service is taking place outside the jurisdiction? So if the service takes place within the jurisdiction, that principle has no application.
No, my lord, I wouldn't accept that, because I say that that isn't how this general rule is cast. The general rule is cast as those against those subject to, i.e. within the jurisdiction. So if you are without the jurisdiction, regardless of whether you have a service address within regardless of where the service takes place or purports to take place, you have to. It's about where the subject is. It's not about where the service is. If I can put it that way.
Is that right, as a general principle? Because I thought that it was absolutely standard for foreign persons and entities to give an address for service in the jurisdiction for the very purpose that you didn't then need leave to serve them out.
But that's subject to a general provision in CPR Part 6. If you effectively you've got a submission to the jurisdiction, haven't you? Because by definition, that is what this provision would have to be. It would have to be effectively a type. I'm not saying it's in formal terms a deeming provision, but effectively a deeming provision. If you give an address in England for service under the Companies Act, you are submitting to the jurisdiction of England.
But there's no dispute that Section 1140 applies to claim forms as well as other documents. It applies to all sorts of documents, but it applies to claim forms. You're not saying it doesn't apply to court proceedings.
Yes.
So why is this not somebody giving an address for service in the jurisdiction?
Because as I say, what subsection 3 is not doing is saying effectively what my lord has just said. There is nothing in subsection 3 that says this section allows for service person not within the jurisdiction.
I see.
Because that's what I say it would have to do for it to be that form of specific provision.
Do we have the SSL case?
We don't, my lord. Sorry, it was an agreed principle of law, and so
Yeah.
I don't think it should be. I apologise if that's a problem. We've got a quotation from it, a lengthy-ish quotation from it in the Key Holmes Bradford Limited case, if your lordship wants to look at it. The next principle is at paragraph 56, which is where the courts have established a general principle of law and the legislature steps in with particular legislation in particular area. It must, unless shown contrary intention, have been taken to have left cases outside that area where they were under the influence of the general law. And again, I suppose, my lord, this is sort of the flip side of the point I've just made, which is you need to show that contrary intention. There has to be a specific provision or clear contrary intention to cut down on the principle of law. And I say subsection 3 on its own doesn't do that, because there is nothing in the statutory wording that, when one reads it, would make one think this has created a new service out mechanism. So that's because effectively what you're relying on is just the words served or service. And the words serve or service on their own don't, I say, show a clear intention, are not a clear intention or a specific provision. And they say whatever the purpose of the document, but I say that service out on somebody outside the jurisdiction isn't the purpose of the document. It's the consequence of a specific rule of law granting service out. But even if I'm wrong on that, I would say that the mechanism in subsection 8, the purpose of subsection 8 is to cut down on that, on the breadth of subsection 3. And so, if subsection 8 has any content, it has to be the content that I've identified. Because otherwise, it doesn't, what it says is that nothing in this section should be read as affecting any rule of law under which permission is required for service out of the jurisdiction. Well, in the reading that effectively that it only applies where somebody's given an address for service outside the jurisdiction, then it is cutting down on that enactment or rule of law, I say. Now, the way this is dealt with in the authorities can be picked up from just one judgment, which is the judgment in Key Holmes and Key Holmes, Bradford and Town, which is behind divider 14. I just want to take you to two passages of this, and this has then been replicated in the other authorities. So I'm not trying to avoid dealing with the other authorities, but this is, I think, the same argument that's dealt with in the other authorities. So at page 134, paragraph 13, this deals with some of the material that the commentary on the bill, as it was. And I just invite you to read paragraph 13 and the quotations therein. And so what I say about that is that there's nothing in that deals with the international situation. What the purpose one gathers from these documents is effectively just to make sure that the administrative mechanism of ensuring the public records kept fully effective is in place. So that doesn't help you, as it were, with how subsections 3 and 8 interact. And so one can then turn on to paragraph 25 on page 138. And if I just invite the court to read paragraph 25. this is the point that my Lord Justice Nugee made to me a few moments ago, which is that effectively the way that the Master Marshal who then was reading this was he said that it's confined effectively to the situation where a foreign person gives a address in England. But my Lord, if one picks it up just between B and C, it seems to me inherently unlikely that in passing Section 1040 of the 2000 Act, Parliament can have intended what was clearly designed to be a new manner in which company directors should be served, should be subject to a common law principle which is directly contrary to the clear terms of the section. My lady, my lords, pausing there, that's putting the test the wrong way round. One doesn't sort of say, well, they can't possibly have been intended to cut down, for their section to be cut down by the common law principle, therefore we'll read down the common law principle. It's the other way around. You have to have a specific provision or contrary intention shown on the face of the statute. And the same goes for the next sentence. Nothing in section 1140 suggests that its provisions are limited such as to prevent service upon a director who's not resident within the jurisdiction. Well, again, I say that's the wrong way around. I say that you have to show the contrary intention or specific provision to enable service without the jurisdiction. So that's my answer to that. So those are my submissions on section 1140. I had some concluding submissions, but I think I dealt with them in argument with Lord Justice Nugee about how I say my grounds interact. So unless there's anything further I can help the tribunal with, those are my submissions.
I think we have the point about how you say they interact.
Yes.
Thank you. Thank you very
That's
much
great.
indeed, Mr. Sherman. Mr. Norbury?
In fact, it's me, my lady, Mr. Richardson.
Oh, I'm so sorry.
Not at all. Might I start by, my lady, just by asking when you're planning to rise?
1 o'clock.
Excellent. My lady, my lords, my lady friends very helpfully and fairly set out the issues really before the court today. What I'm going to do on ground one, which is obviously the principal reason we're here today, is set the scene from our perspective briefly, and then firstly address the basis upon which a judge found below we're calling the enforcement ground for permitting service out, and then addressing the other basis which we put in our respondent's notice and which the judge didn't find on below, which we're calling substantive ground. I'm not planning obviously to go over every point in my skeleton, but if I don't refer to them orally, they're obviously still part of my overall submission to the court. Just so we're all clear on what the test is that my client must meet for joinder and service out, there's no dispute that at this stage to obtain joinder, all PIFs has to show is that the case against the children heirs is not strikeable. My learned friend accepts the position articulated in paragraph 42 of my skeleton, quoting from the Peace Bihar decision. And there's no dispute that all PIFs has to show is a good arguable case that the children heirs are proper parties, and there's a serious issue to be tried against them to obtain service out on them, as the judgment says at paragraph 43. Hence, for my learned friend to succeed, he has to, as he fairly incorrectly says, identify an absolute bar under English law to PIFs being entitled to join and serve out on his clients. His grounds of appeal, which I won't take you to, puts that all in relation to service out, a challenge to service out. But to be clear, as I understand his case, if he's wrong, as it were, on service out, if we're entitled to serve out on the basis they're proper parties, he doesn't suggest that for some other reason it was improper to join them to these proceedings. I will just mention subparagraph 3 of the grounds of appeal, which posits in the alternative a forum conveniens argument. So he says even if he's wrong, if you like, on his knockout point, well, it's still not the proper forum for the dispute. I don't, in fact, understand that, as it were, to be pursued by him, save as set out in paragraph 44 of his skeleton, which, as I read it, doesn't in substance add anything to his principal submissions, i.e. he's only saying, in effect, well, it's also not a convenient forum for the reason that I've actually got a knockout blow against England being able to proceed against my clients at all. And that was certainly also how he fairly put the case below, as you can see from the transcript at page 100 of the core bundle. So my own friend case all depends on him having what I'll call a knockout point, and we obviously accept that if he does have that knockout point, let's say that under English law it's impossible for his clients to be joined and served with our claim, then the claim against them should not continue. Before we get into the weeds of that, just standing back, in my submission that's unlikely to be the correct outcome because of the obvious potential injustice which would flow from it, which you've been exploring in part with my learned friend this morning. As I think my lady put it to my learned friend, if as we call him Far, if Mr. Rajaan was still alive, and when he was alive, he was actively defending the claim, was fully engaged in this jurisdiction with the claim against him, and had judgment be entered against him, there's no doubt that PIFs could have taken that judgment and enforced it against him and his assets, wherever they would have been in the world in the usual way. There was, when he was alive, a unitary holding of his assets and sole legal responsibility on his part for his liability to PIFs, which would have permitted that enforceability. Now we know on death that his assets in different jurisdictions vest in different persons who are responsible separately for the discharge of his liabilities from the assets that they hold. We're concerned here with Switzerland. It's uncontroversial that by automatic operation of the principle of universal succession, which is a principle of substantive Swiss law, his assets there have passed to his widow and his children, and that unless and until they disclaim them effectively, they are in effect charged with what in England would be characterised as administration. They're responsible for the discharge of his liabilities. It's also uncontroversial, and this, in my submission, is a very important point, that from a Swiss perspective, a Swiss court regards the English court as having jurisdiction over the children heirs, just as it did over their father when he was alive. And indeed that it would expect and indeed require that all of the children heirs be joined to and served with the English proceedings in place of their father, in order for the judgment given here in respect of his liabilities to PIFs to be recognised and enforced against them in Switzerland. And it would be useful, I think, at this point just to go to Professor Jacob's report in that respect. That's in the supplemental bundle starting at page 148. You'll see there's a header in the middle of the page saying joinder of a deceased's heirs as additional defendants. And he was asked the question, assuming they're not domiciled in England, on what basis would a Swiss court recognise that the English court had jurisdiction in respect to the heirs? And he says at 3A1, as a consequence of the principle of universal succession, the community of heirs succeed to the decedent with regard to all their legal positions, including their liabilities, so long as they're not highly personal. That doesn't apply here. The principle of universal succession also extends to procedural particularities, such as the special rules pertaining to jurisdiction that apply to the deceased. Therefore, if court proceedings had been initiated against the deceased before their death, and the court had jurisdiction against the decedent, the court continues to have jurisdiction against the decedent's heirs. The legal basis is Article 560 of the Swiss Civil Code and the therein embedded principle of universal succession. So far as Switzerland is concerned, there are properly constituted proceedings in this jurisdiction against first Far, and now automatically and necessarily against his children. And that flows from the general proposition of universal succession, which I think we looked at with my learned friend, but it's also explored a little further by the professor at page 137, paragraph 1A1. And you'll see about 3 lines down, he says, this means at the very moment of the deceased passing, the heirs automatically succeed to the decedent with regard to all the decedent's assets and liabilities. He says a bit further down, the decedent cannot stipulate otherwise. The principle of universal succession is binding and cannot be derogated from. It happens automatically. and so on. And then just over the page, or a couple of pages over at 143, at 2A, he's here talking about, you'll see the question at the top of the page, enforcement of an English judgment in Switzerland after a defendant's death. What rules of the Swiss court apply if a judgment creditor sought to have the judgment recognised and enforced in Switzerland, and so on. And then he starts at 2A2, telling us that under national rules, recognition and enforcement of foreign judgments is a matter of contract and tort law, are governed by the general provisions of Article 25 of the Swiss Private International Law Act. I think we can then skip, if you can, further down in that paragraph over the page. We're about 6 lines up. It says, Article 26 lists further situations where a foreign authority is considered to have jurisdiction. For example, pursuant to Article 26, a foreign decision will be recognised and enforced if, in a matter involving an economic interest, the defendant proceeded on the merits without reservation, i.e. they did not contest the court's jurisdiction on submitting a defence on the merits, and that was obviously the position of Mr. Rajaan in England. And then he says, the domicile or habitual residence of the defendant at the time of filing the claim are decisive, not the circumstances at the time the judgment being rendered. And then this is the important bit, accordingly, the fact that one or several individuals succeeding the defendant in foreign proceedings may not have been domiciled in England when the court reached its decision will not prevent recognition and enforcement in Switzerland, as long as, from the Swiss point of view, the foreign court had jurisdiction against the original defendant. So, in other words, the fact that the children heirs are spread out across the world doesn't matter, so long as the English court had jurisdiction over their father during his lifetime. It continues to have jurisdiction under Swiss law over them as his heirs on his death. So, my lady, my lords, what the Swiss court would envisage ought to happen here is that the claim would continue against the children heirs because the English court would join them to the proceedings. And there's obviously obvious justice and sense in that outcome being achieved, and that I think was obviously very much in the mind of the judge below. It's also clearly very much in the mind of Mr. Justice Robin Knowles in the Mozambique decision, which is in the authorities bundle. He averts to that at paragraph 32 of his judgment, which is at page 449.
Sorry, can you just get that out?
Yes, my lords. It's at tab 20 of the authorities bundle. And I was just referring on page 449.
449.
Was I referring to 449? Yes, 449, paragraph 32. If, contrary to the above, the English court was to insist that there is an estate with a legal identity, that this matter involves the administration of that estate, that succession has not been reached, and that in these circumstances the heirs should not be added as defendants, then the English court risks leaving matters and decision from the trial unrecognisable in a relevant foreign jurisdiction. That would not be an outcome to be accepted lightly. And then for the reasons he gives, he decides it's not one he's compelled to reach. So my learned friend's case is, as it were, not that there is any problem, so far as the Swiss court is concerned, with this court assuming jurisdiction over his clients. To the contrary, that is what the Swiss court would expect to happen. His case is there is an absolute bar, nonetheless, under English law, arising from the manner in which it conceives of the administration of estates, to the English court being able to do what would seem to a Swiss court the natural and sensible thing for it to do. And that isn't, if you like, merely an academic matter, because, as you were testing with my learned friend this morning, the logical consequence of his position is that if his clients don't voluntarily accept the result of an English decision determining that their father did defraud my client, in order to go against assets in Switzerland held by them, it would have to relitigate in Switzerland with a new originating process. That I think also follows, and I'll take it to you when I can find the reference, from what Professor Jacob says, and it goes to why he says the children heirs need to be named parties to these proceedings in order to be enforced against in Switzerland, because essentially he says in enforcement proceedings in Switzerland, unless they are individually named defendants to a set of proceedings, the Swiss courts simply won't recognise the foreign judgment as binding upon them. So we would have to relitigate in Switzerland. And that, of course, potentially means, not suggesting it necessarily does in this case at all, but potentially means limitation defences may have arisen in Switzerland because they would have arisen in Switzerland had we only just now been suing the father, had he remained alive in Switzerland, which don't arise at all in England because the proceedings were timelessly brought against the father in this jurisdiction, and where, as I say, and I will labour the point again and again, where a Swiss court will have no issue with the heirs stepping into the father's shoes in England for limitation purposes as well. So there's no world in which the children heirs can claim limitation defence in England in the English proceedings, which a Swiss court regards them as automatically succeeding to and the English court having jurisdiction over them in relation to. Whereas on my learned friend's case, if they have to go again in Switzerland, a Swiss court scratching its head as to why on earth this is happening, would nonetheless potentially have to give effect to limitation defences which then arise in new originating process in Switzerland. And that obviously risks radical injustice to my clients. They couldn't predict the death of the deceased in this jurisdiction. They couldn't have commenced proceedings against the heirs in Switzerland before the father died because they weren't heirs at that point. So that all goes to why I say my own friend's position, were it to be correct, producing that sort of radical potential injustice is very unlikely. And it's also very unlikely in my submission because his case obviously doesn't rise on the basis there's a statutory reason why the English courts are prevented from, if you like, preventing that sort of injustice. He's saying it's a common law rule, or set of common law rules, which create this situation, notwithstanding the injustice that may flow from it. And that, in my submission, is an inherently unlikely position. So that, my laws, is scene setting.
And so is this a convenient moment?
It looks
for
like
you?
it's a convenient moment, yes.
And I know we asked lots of questions this morning, and so time was elongated, put it that way. But how long do you expect to be this afternoon?
I shall take it as quickly as I can. I suspect I can be extremely brief on the second ground of appeal,
Yes.
section 1140, because frankly I've been struggling to conceive of what I could say to your ladyship and your lordships that the Chancellor didn't say in the PJSA bank case, and I'd just be parroting him, I think. And I'll take what I need to deal with on ground one as quickly as I can. I mean, as a sort of headline point, I think the key point for me to have to deal with is why the position of persons such as the children heirs under Swiss law is so distinct from the position of foreign personal representatives, notwithstanding the Court of Appeal authority that I handed up yesterday, or this morning, they can and should probably be joined to English proceedings. So that's what I'll focus on principally this afternoon.
Thank you very much. 2 o'clock.
Well, Rajaan,